Subcommittee will come to order. I'm pleased to welcome you today to the hearing before the Subcommittee on Crime, Terrorism, and Homeland Security on war profiteering and other contractor crimes committed overseas. Over the last 4 years, reconstruction fraud has run rampant during the engagement of U.S. forces in Iraq and Afghanistan. The United States has devoted more than $50 billion to relief and reconstruction activities in Iraq and Afghanistan, and the inspectors general that are here before us today have reported that millions of these dollars are unaccounted for. Billions may have been lost to fraud and other misconduct, and these inspectors general have opened hundreds of investigations into fraud, waste, and abuse into Iraq, Kuwait, and Afghanistan, involving illegal kickbacks, big rigging, embezzlement, and fraudulent overbilling. In addition to the fraud, there's well-documented evidence of detainee abuse perpetrated by contractors, as well as evidence of unjustified shootings and killings by private security contractors. Private contractors have been used to a greater extent than at any other time in our history. The exponential use of contractors comes with the exponential use of contractors comes the greater scrutiny of which laws, if any, they're exposed to. And we currently have a situation in which many contractors act with impunity and no accountability because they operate outside of the physical jurisdiction of the United States and therefore outside of the jurisdiction of the U.S. Criminal Code. I hope that at this hearing we will be able to explore the following questions. What is the extent of the problem? Why are there so few prosecutions? What are the reasons for the lack of transparency in investigations and prosecutions? And are the existing laws adequate to address these problems? With respect to the first point, considering the vast amount of evidence and investigations, there have been relatively few prosecutions for fraud or detainee abuse. The inspectors general before us have more than 70 open and active investigations in contracting fraud and abuse in the war. In addition, private whistleblowers have filed numerous civil claims involving Iraq fraud under the False Claims Act. Despite the breadth of all of these investigations and cases, the Department of Justice has pursued only a relatively small number of the cases, and it has not even participated at all in the whistleblower cases. With respect to detainee abuse in Iraq, there has only been one successful prosecution of a civilian contractor, and that was for the conviction of a CIA contractor for beating a detainee who later died. Another question that arises with respect to prosecutions and investigations is the lack of transparency. For example, 17 pending cases of detainee abuse, including the abuse at Abu Ghraib prison by contractors, have remained on the docket of the U.S. Attorney's Office in the Eastern District of Virginia for 3 years. In some of these cases, the Army has investigated the circumstances behind them and found probable cause that a crime has been committed and referred these cases to the Department of Justice for prosecution. But we are not told why these cases are being held up and what the next steps are for prosecution. On the fraud side, the Department of Justice has ignored the False Claims Act cases by obtaining court orders sealing the cases. Most of the cases filed regarding the war profiteering in Iraq has remained under seal. Finally, we need to examine whether the laws are sufficient to address the problem, whether the present laws on the books are sufficient to address the problem. Although there are anti-fraud laws to protect against waste of the United States dollars at home, no law expressly forbids war profiteering or expressly confers jurisdiction of the U.S. federal court to hear fraud cases outside the normal bounds of the United States Criminal Code. To this end, the gentleman from Hawaii, Mr. Abercrombie, has introduced H.R. 400, the War Profiteering Prevention Act of 2007, a companion bill to Senator Leahy's War Profiteering Act. The legislation would criminalize overcharging taxpayers to defraud and to profit excessively from a war, military action, or reconstruction effort. The crime would be a felony, subject to criminal penalties of up to 20 years in prison and fines up to $1 million, or twice the illegal gross profits of the crime, whichever is higher. The bill also prohibits false statements connected with the provision of goods and services in connection with war reconstruction effort. This crime would be a felony, subject to the criminal penalties of up to 10 years in prison and fines up to $1 million or twice the illegal gross profits of the crime, whichever is higher. In sum, the bill sends a clear message that all contracting fraud, whether it occurs in Iraq or elsewhere overseas for exorbitant gain, is not only unacceptable and reprehensible, it will be illegal. With respect to the detainee abuse and other human rights crimes committed overseas, we need to examine whether the federal courts have the appropriate authority to hear such cases. While some abuses by military and some security contractors may be prosecuted under current U.S. law, there have been calls to clarify and amend the Military Extraterritorial Jurisdiction Act, the MEJA. When that was signed into law in 2000, it provided the United States courts with jurisdiction over only those civilian employees, contractors, and subcontractors affiliated with the Defense Department who create crimes overseas. The law was later amended in 2005 to include employees of any federal agency supporting the mission of the Department of Defense overseas. We need to make sure that the growing number of contractors overseas do not escape accountability simply because they are not deemed to be supporting the mission of the Department of Defense. To this end, on January 10th, the gentleman from North Carolina, Mr. Price, introduced H.R. 369, the Transparency and Accountability in Security Contracting Act of 2007. The bill includes two provisions which would close the loophole to cover all private security contractors, not just those associated with the Department of Defense, to ensure that they are accountable under U.S. law. He also recently introduced the provision as a standalone bill, H.R. 2740, the MEJA Expansion and Enforcement Act of 2007. So today I hope we can determine what kind of priority the Department of Justice assigns to reconstruction fraud cases, why many cases have not been prosecuted, and what can be done to correct the situation, whether it's through legislation, more resources, or other actions.